Excellencies, ladies and gentlemen, colleagues, dear friends. Today is a special day in the long history of Ukrainian-Russian gas disputes. It is the one-year anniversary of the first award, the so-called separate award in the arbitrations that were initiated in 2014, an award where Naftogaz was largely successful. In particular, the arbitral tribunal rejected Gazprom's huge and ruinous claim for take-or-pay payments in an amount of US dollars 46 billion. And then the tribunal also effectively reduced the take-or-pay volumes going forward to 1/10 of the original volume, and also set aside an illegal destination clause. In addition, the tribunal awarded Naftogaz's claim for a market-reflective price for the gas bought under the gas sales contract with Gazprom. And we have now received the two last awards, the final award in the gas sales arbitration that was received on 22nd December 2017, and then the transit award on 28 February this year. And I would say we have reason to be satisfied. We have reason even to celebrate. In addition to the successful outcome in the separate award on take-or-pay and pricing as confirmed in the final award, Naftogaz in the transit award was awarded more than 4.6 billion US dollars in damages for under-deliveries. And when this amount was set off against previous underpayments by Naftogaz in 2013 and 2014 under the gas sales contract, the end result was a net claim for Naftogaz against Gazprom in an amount of US dollars 2.56 billion, which has now grown to more than 2.6 billion when interest is taken into account. Now, following these awards, we have also seen the fallout from the tribunal's decisions as reflected in Gazprom's reactions. In short, Gazprom refuses to comply with the awards and seeks to reverse the outcome in a new arbitration, as well as to set aside and nullify the outcome in challenge proceedings before the ordinary courts of Sweden. This is therefore an appropriate time to take stock of the situation, both in respect of the previous arbitrations and their implications for the parties, and in respect of further proceedings that have been initiated. We are now, in a way, at a crossroads where one chapter, in our view, has been closed and a new chapter has been opened. This is not the beginning of the end. It is the beginning of a whole new series of legal proceedings. But before I turn to that, let's first look at the previous arbitrations and how it all started. Now, from our perspective, it all started during Easter of 2014. I was holidaying in France with family and friends when I, through Kjetil Bø, who you heard, received a request to come urgently to Kiev to discuss the gas contracts between Naftogaz and Gazprom. Now, in advance, I already knew the contracts because they had been published when they were entered into in January 2009. And so did my colleague, Mr. Haga, who joined me on short notice in Kiev for meetings with Naftogaz and the Ukrainian government. And as you may recall, these were turbulent times in Ukraine. The Yanukovych regime had been overturned, and Russia had occupied and annexed Crimea. At Naftogaz, a new management had been installed. It's the new management that you will see here today. The new management was confronted by Gazprom's cancellation of a gas price discount that was granted in December 2013, as well as a withdrawal of a gas price rebate that was granted in 2010 as compensation for the presence of the Russian Black Sea Fleet on Ukrainian territory, in particular the naval base at Sevastopol in Crimea. Now, as a result of these withdrawals of rebates, Naftogaz was faced with an immediate and significant increase in the gas price, which by far exceeded the level of market prices in Europe. And the price increase served to exacerbate the burden of the comprehensive and imbalanced take-or-pay obligations under the contract. Now, it was against this background that Naftogaz shortly thereafter issued a notice of dispute that was on 27 April 2014, claiming a significant reduction of the price, the setting aside of the destination clause in the contract, and reserving the right to make further claims, in particular regarding the take-or-pay obligations. And subsequently, a claim for invalidity and revision of the volume and take-or-pay provisions was subsequently added to the claims. Formal arbitral proceedings were then commenced on 16 June 2014 by both parties. At the same time, Gazprom ceased deliveries of gas to Naftogaz. And then, later that summer, on 25 July 2014, Naftogaz also issued a notice of dispute under the transit contract, claiming revision of the contract, including the transit tariff in conformity with European and Ukrainian law, as well as compensation for underdeliveries. Now, altogether, the main objective of Naftogaz's claims was to bring the contracts into conformity with generally accepted and market-reflective European principles for gas sales and gas transit, in accordance with the ostensible original purpose of the contracts. A further objective was, of course, to ensure the equality of the parties under the contracts as part of the political struggle between Russia and Ukraine. Now, during the summer of 2014, the EU Commission arranged for trilateral talks in Brussels, headed by the then Commissioner for Energy, Günther Oettinger. And his approach was a bit unconventional, perhaps. His approach was to conduct the negotiations in the middle of the night in the Baden-Württemberg mission in Brussels with food and wine, and try to force the parties to agree, even by suggesting a specific price. But it did not work. However, the Commission played a very useful role in many other respects, in particular by later brokering a deal on Russian gas deliveries in winter, the so-called winter packages. Now, the summer and autumn of 2014 was also the time for a number of activities to get the arbitrations going. That is, establishing the full legal team, which, besides Wikborg Rein, included Swedish Counsel Gernandt and Danielsson, they are here today, as well as Ukrainian Counsel Aekwa, they are also here today. And on the expert side, the Brettel Group was here, as well as Tony Way of the Energy Contract Company. That was the Naftogaz team. Of course, in addition to Naftogaz's own people. Tribunals needed to be established. The tribunals would be appointed by the parties. And we had a language issue because the language of the arbitrations, according to the contracts, was Russian. We agreed with Gazprom to change to English. In the end, we ended up with the same tribunal in both cases, consisting of Swedish lawyer Tore Viven Nilsson as chairman, Danish lawyer Jens Rostock Jensen, appointed by Naftogaz, and former Swedish Chief Justice of the Supreme Court, Johan Munk, who was appointed by Gazprom. Now, given the values at stake, the relationship between the parties, and the complex nature of the relevant legal and factual issues, the proceedings in these cases were extremely comprehensive and challenging. While war may be politics by other means, the arbitrations were more like negotiations by other means, but with a certain warlike quality, and of course resolution by an independent panel in the end. Involvement on both sides was at the highest management and political level, and in our case this led to a very fruitful and efficient cooperation between the legal and expert team on the one hand, and Naftogaz's management and authorities on the other hand, with a clear understanding of roles and responsibilities. Then numerous written pleadings and oral hearings were exchanged and took place between April 2014 and the end of February 2018, a period of almost 4 years. And as I said in the beginning, we are very satisfied with the outcome of the awards, which are also, in our view, extremely comprehensive and well-reasoned. Now, Gazprom's unhappiness with the first award regarding pricing and take-or-pay became evident when Gazprom challenged the award before the ordinary courts of Sweden in November last year, subsequently followed by challenges of the 2 other awards, as well as initiation of a new arbitration to try to reverse the outcome of the previous arbitrations. And the main question is then, is this at all possible? Is it legally possible? Is there any possibility, so to speak, that Gazprom may succeed in their endeavors? In both instances, we would say no, or highly unlikely, based on ours and Swedish Counsel's best legal judgment. The awards are final and legally binding, and the same issues cannot be relitigated in a new arbitration based on the procedural legal principle of res judicata. In any event, we see no merit in Gazprom's substantive arguments, essentially that the previous awards have created an imbalance in the original contractual relationship. If anything, it is our view that certain issues are still outstanding in respect of a further revision of the original contractual relationship, as well as proper implementation of the awards, which we are now pursuing. The challenge proceedings before the ordinary courts of Sweden are, in our view, equally unlikely to succeed. These proceedings are founded on alleged grave procedural errors committed by the tribunal, as well as considerations of public policy that are, in our view, totally without merit. And then this week, as you may have seen in the media, Gazprom added a new ill-founded ground in its challenge proceeding, namely that a significant part of the transit award allegedly had been written by somebody else than the tribunal. And for some of you, this is known as the so-called UKOS defense, which was one of the grounds for defense that was used by the Russian Federation in its arbitration with the UKOS shareholders. And this allegation was then never tried in that case. Now, statistically, the chances of success in Swedish challenge proceedings are also very low, around 6%, according to a representative Swedish study. However, having said that, we are taking the challenges and the new arbitrations extremely seriously. Gazprom has announced its determination to use all legal means to overturn the awards. We, on our part, will use all legal means to protect the integrity of the awards, including enforcement of the awards. Notably, Gazprom has still not paid the $2.56 billion awarded to Naftogaz, which Gazprom is legally obliged to pay as of the date of the award, irrespective of the new arbitration and irrespective of the challenge proceedings. And as you may have seen these last days, enforcement action has now been initiated in Switzerland, the Netherlands, and England, and more will follow, as announced by the Ukrainian president yesterday. And of course, we are listening to his advice. In addition, Naftogaz has initiated new proceedings for a revision of the transit tariff, which was not decided in the previous arbitration and therefore is not res judicata. Naftogaz has also submitted several counterclaims in the new arbitration, inter alia to force Gazprom to comply with its delivery obligation pursuant to the final award, as well as for damages. Again, these counterclaims were not decided in the previous arbitrations and therefore are not res judicata. Now, in conclusion, what we are presently witnessing in terms of Gazprom's failure to comply with the awards and attempts at reversing or setting aside the outcome of the awards are truly extraordinary, but also illegal in respect of its failure to comply with the awards. In our view, this raises serious concerns about Gazprom's reliability as a serious commercial actor. Only last week, the European Commission entered into a settlement with Gazprom over its abuse of dominant position in Eastern and Central Europe. And the question is then, can Gazprom be trusted to fulfill its commitments? We also have reason to be concerned about any extra-legal countermeasures that Gazprom or its majority shareholder, the Russian Federation, may take in respect of lawful enforcement of the awards by Naftogaz. Gazprom and the Russian Federation would bear full responsibility for such an escalation. Now, Naftogaz does not seek confrontation and will defend its interest by legal means. Naftogaz would also like to have a normal commercial relationship with Gazprom in the future and has made a number of proposals to this effect. In particular, Naftogaz has suggested continued transit of Russian gas through Ukraine after the expiration of the current transit contract in 2020 on commercial terms. Thank you very much. That's all I had to offer at this stage.